Thanks, Tom. So first of all, good morning, everyone. And can I add my thanks for attending this session this morning and for choosing to spend your first morning of lockdown 2.0 with us. As Tom said, my name's Jo Rhodes and I am a senior associate in the firm's commercial litigation team. In terms of my practice, I do general corporate and commercial litigation and also quite a lot of domestic and international insolvency litigation, as well as fraud and asset tracing work. Privilege, which I'm going to talk to you all about today, pervades through all those types of work, through all types of litigation, and actually beyond that into day-to-day practice. If it's accidentally waived, which can easily happen in an in-house environment, it can cause issues. So it's definitely something that's worth thinking about and getting it right. Privilege is a tricky topic, and I'm very conscious that we could spend hours talking about each aspect of privilege and debating the merits of various approaches and the views taken by the court over the last 20 to 30 years. I'm sure you're all much too busy for that though, so what I've tried to do instead is to put together much more of a practical overview of privilege in terms of how each type of privilege might apply to you, along with some hints and tips as to how you might best manage and maintain it, working with the business in an in-house team. I don't have any slides for this talk, but you might have seen there was a handout sent with the joining instructions with the key points on there, so please feel free to follow along with that as we go. So to start with then, and taking it right back to basics, what is privilege? At the heart of it, privilege is a legal concept which entitles a party to withhold evidence from production to a third party or to the court. What that means in practical terms is that it operates as a shield to protect you from having to hand over difficult documents if you get into litigation. In the English courts, we have what's known as a cards on the table approach, which means that if you get that far in proceedings, you will have to give disclosure at a certain point. That's an onerous obligation because all documents, even if they're difficult or commercially sensitive, have to be disclosed unless you can rely on some sort of privilege to prevent them from being sent across. And this is why it is so important. So I'm now going to run through the various different types or the main types of privilege with a brief overview of each one. So starting with legal advice privilege then, and I think this is the one that most people probably immediately think of when they think of privilege as a concept. And so just a couple of examples of when legal advice privilege might kick in. So if the business asks you for some advice on an agreement which they're considering entering into, generally your advice on the terms of that agreement is going to be privileged by way of legal advice privilege. And similarly, if you come to us and ask us to draft some documentation for you, our advice on that documentation is also likely to be privileged. So in terms of the definition that's generally adopted of legal advice privilege then, it applies to confidential communications between lawyers and their clients, which are made for the dominant purpose of seeking or giving legal advice. So what that means is it protects legal advice. And that's reasonably straightforward if you've got external legal advisors acting for you, but it's slightly trickier where in-house counsel is giving advice to the business for some of the reasons I'll come on to later on. So first, to break down the various elements of legal advice privilege then. So the first requirement is that there is confidentiality. Now, in most cases, confidentiality will automatically apply to legal advice privilege because the nature of the communications, i.e. between a lawyer and their client. But if you lose privilege, if you lose confidence in the documents, privilege will be lost. So it is an important concept to get right. What it doesn't do normally is prevent you from sharing advice that is given with the business, provided that advice is shared on terms of confidentiality. So for example, you can normally disclose to board members or that advice, although ideally it won't be recorded in board minutes if at all possible, because often those might need to be made public or circulated more widely, and that would mean confidentiality in the advice was also lost. There are ways around that though, so you might think about putting any advice in a confidential appendix to the board minutes, for example, so confidentiality in it can be maintained if the board minutes themselves have to be made public. And generally, an employer can disclose with employees the legal advice that's been given if they need it for the purposes of their work without loss of privilege. Everything is going to be taken on a case-by-case basis. These are just general guiding principles. Generally speaking, and it stands to reason, that the bigger the circulation of the legal advice, the bigger the risk is of losing confidence in it and running the risk that it's going to have to be disclosed later down the track. Generally speaking, to maintain confidentiality, the circle to whom the advice is circulated should be kept as small as possible. It does mean, the confidentiality requirement does mean, for example, that anything passing between either party and an opposing party can't attract privilege, even if it reveals the sort of advice that's been given, because the confidentiality in it will be lost. And it's worth noting that that will include notes of calls you might take between you and the other side, unless, for example, you've annotated it in a way which might constitute advice. So the second requirement is that there is a communication. Now, although that's the word that's used in most kind of standard definitions of legal advice privilege, I do think it's a bit misleading because a communication between a lawyer and their client isn't actually required. It was confirmed in the Three Rivers case that legal advice privilege does extend to material which evidences the substance of confidential communications which pass between a client and their lawyer for the purpose of giving or receiving legal advice. So what that means is if something, for example, a memo is prepared in the course of giving legal advice and subject to satisfying the other requirements, that will generally attract legal advice privilege, whether or not it is eventually sent on to the client. The third requirement for legal advice privilege to apply is that there is a lawyer. Now that sounds really obvious, but for legal advice privilege to apply, the communication has to involve a client and their lawyer. That includes all members of the legal profession and does extend to in-house lawyers, but there's a couple of important caveats to that, which I'll talk about in a second. There's an interesting development recently in the TAFNEF litigation, in which the court confirmed that legal advice privilege extends to communications with foreign lawyers, including where those foreign lawyers are in-house themselves, provided they're acting in the capacity of or function of a lawyer. And importantly, the court confirmed that there's no additional requirement that foreign lawyers should be appropriately qualified or recognised or regulated as professional lawyers in their home jurisdiction. That's potentially of interest to those of you who work for multinationals with in-house lawyers in more than one jurisdiction. The fourth requirement is that there is a client. So the courts have generally adopted a narrow definition of client for these purposes. That means that the safest approach from your perspective is to assume that it only applies to employees who are charged with instructing the lawyers and who are authorised to receive legal advice, although other documents might be covered by litigation privilege, which I'll come on to in a moment. The fifth requirement is that the communication comes into existence for the dominant purpose of seeking or giving legal advice. So I've said that legal advice privilege does or can extend to advice given by in-house lawyers. But that being said, it was confirmed in the Three Rivers case where a solicitor or a lawyer is acting not as the client's legal advisor, but as the client's man of business. There's no privilege in those communications. So what's the practical effect of that for you guys then? What that means is that in circumstances where you as an in-house lawyer also have a management, a business or an administrative role, for example, you might also be the company secretary, or you're being asked to provide commercial or strategic advice, privilege is unlikely to attach to communications regarding those roles, or at the very least, it's a grey area. and I'll come on to how to manage that a little bit later on. More generally, the document has to come into existence for the dominant purpose of giving or receiving legal advice about what should be done in the relevant legal context. And the fact that it's the dominant purpose was confirmed in the CAA and Jet2.com litigation earlier this year. What that means is that background documents which are included by a client when seeking advice from a lawyer won't necessarily benefit from legal advice privilege if they existed before the need to seek legal advice arose, obviously unless they attract a different form of privilege. And indeed, they are likely to form part of any disclosure obligations later down the track if it's something you're relying on or something which harms your case. So that's legal advice privilege in a nutshell. Moving on to litigation privilege then. And this is what I would call as the second main type of privilege. And this applies to confidential communications between lawyers and their clients, or the lawyer and or client and a third party, which come into existence for the dominant purpose of being used in connection with actual or pending litigation. You can gather from that definition that the scope of this sort of privilege is quite a lot wider than the scope of legal advice privilege, which essentially means that, subject to what I'm going to say in a minute, once you're into the realms of litigation, it's slightly easier to assert privilege. So an example of when litigation privilege might apply, but legal advice privilege wouldn't apply, is if you as in-house counsel or we as outside counsel communicate with either an expert witness or a witness of fact about their evidence. So the first requirement of litigation privilege is that the communication has to be between a lawyer and a client, or one of them and a third party, for example, as I've said, an expert witness. So you can see from that there's already a wider possible circulation for litigation privilege to apply than there is for legal advice privilege to apply. The second requirement is that the communication has to have come into existence for the dominant purpose of litigation. Now, generally, where there are judicial or quasi-judicial functions to be exercised by a court or a tribunal, and those proceedings are pending, existing, or they're reasonably contemplated, that will satisfy the litigation element. The dominant purpose test is just that. The document has to have predominantly been created for the purpose of litigation, but it's not an exclusivity test. So it doesn't have to only have been created for the purpose of litigation, as long as the kind of overwhelming purpose was that. I do have to give you a note of caution on this element of the litigation privilege test. While I've said that litigation privilege is wider than legal advice privilege, it does have its limits. It was recently confirmed by the Court of Appeal that for the dominant purpose of litigation element to be satisfied, a communication has to have been prepared for the dominant purpose of obtaining advice or evidence in relation to the conduct of the litigation, and that documents prepared for the wider purpose of conducting litigation generally won't be covered. And the way it came out in that case was because there were documents in question to which the assertion to privilege had been challenged, which were emails between the respondents' board members and stakeholders discussing a commercial proposal for a settlement. And those were held not to be covered by litigation privilege. The kind of net result of that is that if, for example, you have two people in the business who are discussing numbers, purely numbers for settlement by email between themselves, and those communications are held to have a purely commercial purpose, privilege can't necessarily be claimed in those documents. I'll come on to settlement discussions more generally in a moment when I talk about without prejudice privilege, but as I say, I did just want to add that as a note of caution. The third requirement is that there is actual or pending litigation. What that means is that litigation has to be a real likelihood rather than a mere possibility. So a possibility that someone might make a claim at some point is not enough to satisfy this requirement, and nor will be a general apprehension of future litigation. So, for example, if you know that the business is about to enter into a contract with a counterparty which is known for being particularly adversarial for whatever reason, anything you prepare on the basis that there might be a claim in the future with that party won't generally be covered. And the fourth requirement then is that there is confidentiality. This is a developing area. It's clearly not so clean cut when you're sharing with a third party as it is when you've got a client and a lawyer, and confidentiality can't be assumed. Sometimes we think about perhaps putting in place a confidentiality agreement to help with that. And again, although I've said that litigation privilege widens the net in terms of what can attract privilege, that doesn't mean that because you're into litigation, documents should be shared left, right and centre with the whole world, as confidentiality still has to apply to the document or communication in issue. Okay, so moving on to my final type of privilege for today's session. This is what's called without prejudice privilege. So I said that I'd talk a bit more about settlement discussions, which does bring me quite neatly onto this type of privilege, which, as I said, is without prejudice privilege. I think this is one that people might not necessarily think of in terms of a category of privilege, but it's certainly worth looking at as it's another way to keep possibly tricky documents out of court. And how WP privilege operates then is it operates to prevent statements which are made, whether in writing or orally, which have been made in a genuine attempt to settle a dispute, from being put before the court as evidence of an admission. So some examples of when this might apply then. Perhaps most obviously, if a letter or email is written to the other side, which makes or indeed rejects an offer to settle, or if you have a phone call with the other side's in-house counsel to try to come to an agreement, anything said during that call can be protected by WP privilege, and that's provided you've agreed that the phone call is to take place on a WP basis. As to why it's important that these communications can't be put before the court as evidence of admission, it would clearly not be conducive to productive settlement discussions if both parties were constantly worried that the contents of those discussions might be put before the court to support the other side's position. So just to give an example of how this might work in practice, if you decide to make a generous offer of, say, 50% of the claim to the other side, even though you don't admit liability, and the other side rejects it, the fact of your making that offer can't be brought up in court as evidence of liability against you. So I wanted to talk just briefly then about the two different labels of WP privilege that you might see. So the first one is simply without prejudice. And what that means is that it can't be put before the court either in the substantive dispute, so the dispute on liability, or on the matter of costs. So it's completely protected. The second type of privilege you might, without prejudice privilege label you might see is without prejudice save as to costs. Now what that means is that it can't be put before the court in either in the substantive dispute, so on liability, but it can be put before the court on costs once liability has been determined. So, for example, if you've made a generous offer which is rejected and you go on to lose at trial, but the winner hasn't bettered your offer, you might want to be able to show that to the court on the matter of costs to try to persuade it to depart even partly from the usual rule of loser pays the winner's costs, if you can show that costs have been incurred unnecessarily from the date of your offer. So moving on to the second section of my talk, which is hints and tips, or do's and don'ts. So I've got 5 do's and 5 don'ts. So the first do is do consider and document at the outset of the litigation or the transaction who the client is. So i.e. the people who will be charged with seeking legal advice. So within an organisation, that's likely to be the key players who will make the decisions and who will most need to communicate with the legal advisors. My second do, and this is quite an important one, is do label documents, emails, communications appropriately. So you, depending on what you're sending, you might want to mark documents and emails confidential and privileged, prepared for the purposes of obtaining legal advice or prepared for the purposes of litigation, and not for onward circulation. So if you're communicating with the business, for example, when you're giving advice on a contractual query, mark it confidential and privileged, prepared for the purpose of obtaining legal advice, and not for onward circulation. And the same goes for anything that you think might be protected by without prejudice privilege. So if during settlement discussions you're not sure if something is WP, label it WP, but bear in mind that it must be a genuine attempt to settle. So you can't just be labeling things WP left, right, and centre and hoping for the best, because just labeling something WP doesn't make it so. So you can't just mark it as WP and assume it will be protected, because the substance of the communication will be taken into account in the event of a privilege challenge. It's worth mentioning that any labelling of emails or communications, whether you label it privileged and confidential or subject to without prejudice privilege, it won't be conclusive or determinative if a claim to a privileged document is made. So again, it's not just a case of labelling something privileged and kind of hoping for the best, but it's nevertheless likely to be helpful in supporting a claim for privilege to stack the deck in your favour. And also, if you think about it from the perspective of any eventual reviewer in a disclosure exercise, the fact that it's been marked privilege will at least give them cause to pause and think about whether that is privileged or not. So my third do is do control and monitor the distribution of privileged information within the organisation. And this goes mainly to the confidentiality point. The tighter the control that you as in-house counsel can keep on it, the more likely it is to maintain its privilege. So I've put together a kind of checklist of how you might think about doing that, and I do appreciate that things you can or can't do will vary depending on the policies within your organisation and things like that. So the first thing you might consider doing is maintaining a circulation list as to what documents have been sent to who in the business and when. You might want to instruct people who you're sending documents to not to forward on privileged information without checking with you first. And I appreciate that to us as lawyers, that might sound really obvious, but it's not necessarily obvious to others. Before you forward an email chain, check for privileged information, both in the top email and also all the way down the chain. And again, I appreciate that that sounds really very obvious, but you know, in the throes of litigation, things can get quite stressful and it's easy to do things without thinking. So do just make sure that you've checked. And if you can, I would avoid making privileged documents available on shared network drives or folders that you can't control access to. So maybe think about password protecting a file where there are privileged documents, for example. My fourth do is if you can, ensure that lawyers whether they're in-house or outside counsel, prepare internal investigation reports to maximise the chance that something will be privileged. If those have to be done by someone else, and I appreciate that might be the case within your organisation, ask them, if possible, to report orally to you so you can prepare the report. You should then prepare the report on the basis that legal advice is necessary to ascertain the legal risks and obligations. If the report doesn't contain legal advice, though, it's unlikely to be privileged, so that will be a commercial decision to weigh up the importance of the report being written down against the damage it could cause if it eventually has to be disclosed. My fifth do, and I do think this is also a very important one, is to consider offering basic training to the people in the business who are likely to be receiving legal advice from you or outside counsel. And things to cover off in that training would be, privilege and the importance of maintaining it. This is something that we have provided to clients in the past, and it has been very helpful, but training is really, really key. People can create tricky documents, and a good sort of basic message, even if you don't do any full-on training, is don't write anything down that you wouldn't want to end up being read out in open court. I think this is particularly applicable to settlement discussions, because settlement is something that the business might try to do themselves, but please try and make sure they don't do that without reference to the legal team, to make sure that something they've said during those discussions can't become inadvertently disclosable. If they absolutely must try to fix it themselves, try to make sure that they do it on the phone and not in writing, and to agree that those discussions are WP, because someone in the business trying to do their best to fix something can actually, in the long run, cause more damage. My second don't is don't mix up your communications which contain strategic advice or relate to other roles you might have within the business and legal advice. Keep them separate, because that way you'll ensure that you're stacking the deck as much as possible, that legal advice will be protected from disclosure, as the entire communication will be privileged. My seventh don't is don't assume something's privileged just because you've sent it to outside counsel or because someone from the business has sent it to you. A classic example of that would be the business emails you seeking some legal advice and attaches some documents to that email. Although the email itself might be privileged, the documents themselves that are attached won't necessarily be, just because they've been attached to a privileged email. General rule of thumb, which is my next don't, is don't commit something to writing unless you absolutely have to, and ask the business to do the same. If, for example, advice or fact-finding can be done orally, do that if possible. My penultimate don't is don't record internal commercial discussions about litigation. Litigation privilege doesn't apply to purely commercial discussions. If it's commercial only, it won't attract privilege. Again, ideally those conversations would take place orally, but they should at least have an in-house lawyer present. And again, I very much appreciate that this will depend on your business's policies. And again, it will be a commercial decision as to whether it's necessary to demonstrate proper procedures as against the risk of any recording being disclosed. And my final tip is don't panic. If you think something privileged might have found its way somewhere it shouldn't have, there are mechanisms which can help you. So, for example, even if legal advice privilege has been lost, litigation privilege might still apply. And there is also provision in the CPR that if a party inadvertently allows a privileged document to be inspected, the party who has inspected the document can only use it or its contents with the permission of the court. And the court can allow that where there has been an obvious mistake, something has so obviously been inadvertently disclosed that the other party shouldn't be able to use it. And finally, if you are panicking, give us a call and we'll see if we can help.
Hey, thank you very much. I think don't panic is, I think, excellent advice at any time, but in particular in the context of privilege. Now, we have had one question through, and I can promise you all this isn't actually a planted question. But if anyone has any questions, please ask up now. But the question we have is from Jenny, who has asked, there are two bits to the question. But the first bit is, if I write a privilege note that is circulated to directors, is privilege lost if they then pass it on to other members of the business? So if you want to do that bit first, Jo.
Yeah, I think generally speaking, that's going to be fine, provided the person that it's passed on to could be, reasonably defined as the client for those purposes. So if they need it for the purpose of their role, then I think that's generally going to be fine. They're perhaps more likely to be considered a client if the note is redacted such that it only includes the bits which are relevant to them, and obviously do all the usual things to stack the deck as much as you can in your favour. So mark the email, the note, whatever it is, confidential and privileged, not for onward circulation, etc. Obviously, every claim to privilege comes down to its own facts and the substance of the document, but generally I think that's going to be fine.
Excellent. So it really comes down to maintaining control, I guess, and that comes on to the second question, or second part of the question, which is, if the document does need to be shared, do I need to send it out to those individuals direct? I think what Jenny's asking is it better for the communication to effectively go back into the legal team and out again, or to just be forwarded on?
I would say back into the legal team and out again, for exactly the reasons you say, Tom, to maintain control over it. And you as an in-house counsel are much more likely to mark the document appropriately than is someone who is just sending it on. So yes, I would say back to you and then out again.
Excellent. Well, I'm looking at the Q&A box and no further questions. Oh, a question has just popped in. And this question from Megan. Thank you very much, Megan. And it reads, how does legal privilege apply to email chains where the subject line is labelled as privileged, but does not necessarily contain strictly confidential or privileged information? So I guess this is, what effect does a label have, or a label on an email chain?
Yeah, thank you, Megan. I think a label is helpful, but it's not determinative. So if you've got something that's further down in the chain which isn't confidential or privileged, you are running the risk of that being disclosable, although the whole chain might not be. So again, it goes back to one of my either do's or don'ts, I can't remember. But just because something is labelled privileged and confidential doesn't necessarily make it so.
Yeah, I think from my perspective, I'd add as a practical point, taking without prejudice, for example, because that's something that's in the course of certain discussions which Jo and I have been conducting, and without prejudice offers may often be going back and forth. I'm always careful to, even though the subject line of the email probably says without prejudice on it, to ensure that the words without prejudice are added at the top of every individual email as well, just so that, as Jo said, you're stacking the deck and you're doing things in a sort of belt and braces way, so that it minimises any discussion. And this goes towards slightly outside of the, completely outside of the question of privilege, but it's in the same way as when you're using the terminology subject to contract. Again, you need to be being very careful as to whether that wording is there, because potentially not conclude a legal agreement because it still says subject to contract on it when you're actually wanting to agree to something. So yeah, I think it's just something that you need to be constantly aware of, and making sure that that you can, so far as possible, have the correct title and the correct emails. And if that means adding to each email without prejudice, save us cost, or without prejudice, or just legally privileged, then that is more the good.
Yeah, and also a very, very practical point about that is in a disclosure exercise, those emails might end up getting separated out. So if each email is marked without prejudice, that will give the reviewer cause to pause on every single one. So that is, I'd say that's good practice.
So we've got two more questions. Questions are flying in now. The first one is one we may not have an immediate answer to. May have to come back to you on, because it's a slightly unusual question from Marianne. Thank you, Marianne. And that question is: if your practicing certificate has expired, but you are still providing advice, could your communication still attract privilege?
Oh yeah, I don't know the answer to that one. I know that privilege does apply to generally applies to people like paralegals and things like that. But I don't know if your practicing certificate has expired, whether that would be covered, but we can certainly try and find out the answer and come back to you.
Yeah, Marianne, we'll come back to you on that. We'd rather give you the right answer at some point separately rather than the wrong one now. And one further question from Treen, which is question on advice privilege. If your internal client forwards email advice externally, is privilege lost in respect of that email advice only, or in relation to the entire matter?
That's a good question. I'd say you're running the risk of it being waived more generally if something's been forwarded. So I would generally discourage anything from being sent out. And again, if we're talking about stacking the deck, it would be much preferable if that wasn't sent, because I think there is at least a risk that anything further might be waived.
Yeah, I think that's right. I think it will depend from case to case, and as Joe said at the outset, we are necessarily giving sort of making general points on the subject rather than each specific case will turn on the specific facts. But the danger with privilege always is that it's like releasing a thread, and that thread can then be pulled out, and the whole jumper, if I can continue this tenuous analogy, then falls to pieces. And that's particularly the case with litigation privilege as well, because if the party is seen to rely on litigation privilege, there's a danger that then all that litigation advice will need to be disclosed. I will just pause very briefly to see if there are any more questions, but to the extent that you have a question and have not raised it and would like us to pick it up separately, please do get in contact with us, either with Joe or myself, or Susie Barnes, who has sent you the invitations. We'd be very happy to answer those. If there are no more questions, I'll probably draw this webinar to a close. Thank you very much for joining, and we very much hope to see you next week for the softer skills session on delivering excellence in the online environments, which I will be attending necessarily, and also our final session in a fortnight's time on whistleblowing in the COVID-19 era. But otherwise, thank you very much for joining, and hopefully see you soon.
Thank you.